So what happens when you need to be able to call out a bad decision, but you don't have the power to do so? It's simple. You do what Americans do. You change the rules. Find out how to do that now. Thanks for watching Learning with Sprayberry, where we make social studies fun, easy, and educational. Today, we're addressing judicial review. This practice is when the Supreme Court has the power to overturn laws based on their constitutionality. Whatever. If a law is unconstitutional, the Supreme Court can strike it down. The Constitution says that a law can be declared unconstitutional if it violates the Constitution, but it doesn't specify who can declare a law unconstitutional. And the Supreme Court didn't always have this power. Let's dig in and see how it got it. But first, as always, background. The Judiciary Act of 1789 is a law, not an official amendment to the Constitution, that creates the federal judicial system of district and circuit judges, and amongst other provisions, grants the Supreme Court the power of the writ of mandamus, which is the ability to order a lower court or public authority to do what it's empowered to do or stop when it's not empowered to do so. I know that's a lot, but let's fast forward to 1800. You've got Adams, a Federalist, running for re-election against Jefferson, a Democratic Republican. Jefferson wins the election and takes the presidency. But before Adams is out of office, he uses his presidential power and appoints a large number of Federalist judges to positions. Now, it's not against the law. However, it's the fact of when he appointed them. Because he waited until the last minute. Some say until 9 p.m. on his last day. Others say he waited till midnight. Some of the letters giving out positions weren't delivered until Adams was out of office, meaning that Adams was technically appointing judges after his term under Jefferson. But the appointments were written during Adams' term. You see how this causes some problems? Well, Jefferson takes power in March of 1801 and tells James Madison not to deliver the letters, essentially canceling out Adams' nominations. As you can imagine, the judges who were told they were going to get jobs are pretty upset.
Dirty Perky shark, back flat, Fortin, Syllabucket, Martin, Perkaluma.
One of the soon-to-be judges, William Marbury, decides to take the matter to court. He asks the Supreme Court to issue a writ of mandamus, forcing Madison to explain why he didn't get the job and to give him the job. This is where the conflict is. The Constitution sets up the judicial branch, but it doesn't do a good job of defining how the judicial branch works. It gives powers, but not a clear set of rules. And this case brings up three distinct questions. 1. Should Marbury get the job of judge based on the facts? 2. Does the Constitution allow for a writ of mandamus? And last, should the Supreme Court issue a writ of mandamus? As the case unfolded, several things became clear. First, Marbury should get his job. It was given legally under the tenure of a sitting president. Once the appointment is given, signed, and the official seal is placed, it's legal. The time of delivery doesn't really factor in. This isn't the super important part. Next, the Supreme Court decided that they couldn't issue a writ of mandamus. Under the Constitution, there's not a way to force the executive branch to do something. This writ of mandamus idea was added by a law, that Judiciary Act, which meant it's not in the Constitution. So the court overturned the idea of writ of mandamus by stating that this writ wasn't built into the Constitution, so they can't do it. So they declared this law unconstitutional. As a whole, this argument doesn't really seem to matter. However,
please consider the following.
The power to issue a writ of mandamus isn't written into the Constitution, the highest law in the land, but this power is given to appellate courts and not the Supreme Court. By asking the Supreme Court to issue this, it's in effect granting power to the Supreme Court that it doesn't have in the Constitution. So the Chief Justice argued it was unconstitutional. This means that the Supreme Court decided a law doesn't fit with the Constitution, and they gave themselves the power to declare it in conflict with the Constitution. Now, this gives them a power which settles an issue that's been open since the Constitution was written. As a decision, this opens the door allowing the Supreme Court to negate any laws they feel don't honor the spirit or the rule of the Constitution. This power is designed to help keep Congress in check, If Congress passes a law that's going to infringe on a person's liberty, or a constitutional rule, the Supreme Court can define it as unconstitutional, putting it on hold until a final decision is made. This power is both wonderful and scary. It grants the Supreme Court the power to protect citizens from laws that could take away their rights. So let's think about it. The President passes a law that says you can be convicted of sedition if you print or say anything negative about the government. Well, that goes against the First Amendment. So the courts could say it's unconstitutional. Unfortunately, we really did have a president who did this, but it happened before the Supreme Court gave itself this power. On the other hand, this means that the Supreme Court could also allow laws that clearly violate your rights. Think Korematsu versus the US. During World War II, thousands of Japanese Americans were rounded up and put into camps to prevent them from spying for Japan. These were American citizens. Now, one man, Korematsu, sued under the idea that they were violating his fifth, the right to a trial and jury, and the 14th, equal protection under the law. After all, these were American citizens who had committed no crime. In one of the worst decisions in U.S. history, the Supreme Court ruled that this law was passed during a war and was constitutional and necessary to protect the U.S. They did, however, concede that if this law had been passed during peacetime, they would rule that it couldn't be enforced. Now, I know that was a lot, but it's time for the question of the day. Should someone, or a group of someones, have the right to declare laws unconstitutional? I mean, if Congress can pass the law, isn't that good enough? Or should there be a way to double check laws to make sure they follow the beliefs and rules of law? Let me know what you think down in the comments below. If you found this helpful or like what you saw, click like. If you want to see more content, click subscribe. I try to drop a new video every Monday. Make sure you ring that bell so you get notified. Thanks for watching Learning with Sprayberry, where we make social studies fun, easy, and educational. Thanks.